Hello everybody, this is Dr. Cole. I'm speaking to you Saturday afternoon, April 19th, and this will be the week 14 announcement for Political Science 1013 on the 16-week schedule for the spring 2025 term. Okay everybody, we are looking at the material from Unit 7 and 8, which will be the material for the final exam, along with some outside readings I've asked you to take a look at. Everybody, not this week, but next, we'll be moving on from the Supreme Court in Unit 7 to Congress in Unit 8. And our last discussion is scheduled for the 28th and 29th. That will be a week from this Monday and Tuesday. You're asked to look at a New York Times interview with Senator Lankford, who will be United States Senator for those of you who are Oklahomans, and his involvement going back before the presidential election in an attempt to get legislation passed over immigration. So we'll ask you to tell us what you think of that, but that's not coming up until next week. Now what I want to do today, everybody, is finish up with Unit 7, and that'll leave us with Unit 8 that I will talk about the next two announcements after this one for week 15 and 16. And that will get us pretty close to where we need to be for our final exam after the first of the month. Now, looking at Unit 7, we had talked last time about how the Supreme Court does its business, what its jurisdiction is, its status as a constitutional court, exercising the power of judicial review to say what is constitutional or not. And we talked about the politics of Supreme Court appointments and how that has become seriously politicized over the course of your lifetime and mine, going back about a generation or so at least. Now then, at the end of those class notes, I discuss 5 landmark Supreme Court decisions, which is how we refer to important, historic Supreme Court decisions that set major precedents for the rest of the legal and political system. And we mention the court can have a dramatic impact if it has an appropriate case and chooses to do so. And in these cases, arguably the court did so. We begin, I believe, with Brown versus the Board of Education, going back to the 1950s. Now, this is the decision that declared unconstitutional formal segregation of public schools along racial lines. Now, when I was your age, we were in the middle of trying to get this decision enforced, because when the decision came down, I believe I mentioned in the class notes there was a second Brown decision the following year in which it was stated that school districts had to proceed with all deliberate speed in enforcing the original Brown decision, which meant that the controversy really was stretched out through the 60s and into the 70s, okay, when I was your age, roughly speaking. So it's no longer the case anywhere that we have school districts operating one set of schools for white students and another for black students, which had been in the case for much of our history before this decision came down. However, it's true that even today, most students in public schools attend schools where members of their own race predominate. One reason for that, we mentioned in the class notes, was that after about 20 years, the Supreme Court sort of drew back and drew a line and said it was willing to impose desegregation plans so far, but no further. A case came from the Detroit metropolitan area, in which the court was asked to enforce a desegregation plan for that entire metro area. But the problem was that included many, many school districts, and the Supreme Court was not willing to order desegregation across jurisdictional lines. Now, very often you have a central city surrounded by suburbs, and the suburbs will attract more affluent people who often may be white. So we had the phenomenon of white flight, with affluent white suburbanites in some school districts and poor people who were often members of minority groups in central city districts. So that's the reason we don't have any more desegregation or integration of schools than we have. Okay, so the history of all that is discussed in the class notes. Okay. Other important decisions, we talk about the Citizens United decision, in which the Supreme Court up to a point bought the argument that money equals speech, and therefore to a considerable extent deregulated campaign finance in our elections. It's a decision that facilitated the creation of so-called super PACs, or independent organizations independent of any candidate's campaign, who were nevertheless permitted to give money to political parties and candidates. And these have turned out to be the vehicles for funneling a lot of big money into our election campaigns. So that's a decision that remains controversial up to the present time. Then there's the Obergefell decision over same-sex marriage, in which you'll notice Justice Kennedy, who's no longer on the court, disagreed with Chief Justice Roberts. Roberts was in the minority. The Supreme Court found it to be unconstitutional for a state to refuse to recognize same-sex marriage ceremonies. So for the time being, they're all required to do so. Clarence Thomas has said that he would like to revisit this and related questions at some point in the future, but I don't know when or whether that will ever take place. It would be opening quite a can of worms, because marriage ceremonies have been performed and households formed based on this decision. The abortion decisions required us to discuss both Roe versus Wade, going back to the 1970s, and the decision that overturned it almost 50 years later, the Dobbs decision. Okay. Now, for a time, the Supreme Court accepted the argument that several different provisions of the Constitution created rights of a sort that allowed you to generalize a generalized right to privacy. And because of that idea that the Constitution protected a right to privacy, the court ruled in the 1970s that restrictive abortion laws were unconstitutional. Well, as I think we're all aware, this became a tremendous political football. When vacancies occurred on the Supreme Court, presidents felt compelled to appoint justices in line with campaign promises that they had made, very often those were conservative Republican presidents. So eventually, a case came to the Supreme Court from the state of Mississippi, which wanted to, where its legislature had passed a restrictive abortion law, and the Supreme Court went ahead and upheld that law and overturned Roe versus Wade from almost 50 years earlier. So now abortion is back in the hands of the states. Chief Justice Roberts wanted to uphold the Mississippi law, but to stop short of completely overturning Roe versus Wade. And if he had gotten one more vote in support, that's what would have happened. But it so happened that 5 of them were prepared to overturn Roe versus Wade, and so that's what happened. That's where we are with abortion law now in the United States as a result of that Dobbs decision from just a couple of years ago. Now, I've added a 5th landmark decision. This goes back just a few months ago now to last year, in the case of Trump versus the United States, a case that was decided before the presidential election. Trump brought suit alleging that the prosecution of him that was being conducted by special counsel Jack Smith over interference in the attempts to interfere in the 2020 election. Trump's lawyers argued that he was immune from prosecution for those charges. And the Supreme Court handed down a decision that many people said, some people at least said, put the president above the law. But we have to look carefully at what was said. They said that there was absolute immunity for the performance of the president's core constitutional duties. Okay. For other official presidential actions, there was a presumption of immunity. So there's presumptive immunity, which means there's a presumption, but the presumption conceivably could be overcome. So those outside the very core functions, possibly he could be prosecuted. But then there's absolutely no immunity for unofficial acts. And the justices were quick to say not everything the president does is official. Justice Sotomayor, though, wasn't happy with the decision. She seemed to think that the court was empowering the president. If a president wanted to send a hit squad of Navy SEALs out to assassinate an opponent, maybe the president would be immune from prosecution for doing that. Not everyone agreed, but some people were alarmed at the extent of immunity from prosecution that was given to presidents as a result of this decision. So those are all discussed in the last section of your class notes for Unit 7 on the Supreme Court. And that will leave us with Unit 8 on Congress that we will talk about the next couple of weeks. So we have a discussion coming up the 28th and 29th, leading up to our final exam after the first of the month. Okay. I should mention also, while I'm thinking about it, everybody, this week is the deadline to contact me if you would like to do a term paper. I need to hear from everyone about their choice of topic by the 25th, which I believe is the same day. Well, some of the students will be, the other section will be taking an exam that day, but you will not. But that 25th, nevertheless, is the deadline to contact me about your term paper topic if you would like to do a term paper, which is optional and not required. But if you would like to do one, please contact me. You're required to give me your topic by the 25th if you would like to do a term paper. All right. So the next couple of times we'll be talking to you about Unit 8 on Congress, beginning about a week from now at this time. In the meantime, study hard. We will say a bit more about that discussion next time. And we'll begin on Unit 8 on Congress and try to get through about the first half of those class notes next time. Take it easy, study hard. Contact me with any questions, problems, or issues through the course website or at david.cole@opsu.edu. Take it easy.